is now weighing in on arbitration agreements and PAGA actions. And I wanted to just briefly go over what are the facts in the Viking River Cruises versus Angie Moriana case. The facts actually are very typical of what we see in many PAGA cases. Angie Moriana worked as a sales representative for Viking. And at the time of the start of her employment, she voluntarily signed an arbitration agreement as a condition of her employment. In that agreement, she agreed that any employment related issue that she would have with Viking would be resolved in arbitration, not in court, and that the parties would use individual procedures rather than a class or representative procedure, such as a PAGA case. Moriana then sued Viking, alleging a whole array of alleged labor code violations, and she sought the PAGA penalties on behalf of herself, as well as hundreds of current and former Viking employees. So how did the Viking River case get to the Supreme Court? It all started with Viking filed a motion to compel Moriana to litigate her claims in arbitration as required under the contract. The trial judge denied that motion, as well as the Court of Appeal. The Court of Appeal cited to the California Supreme Court rule in Iskanian that an employee does not have to submit to arbitration. And the court made very clear, the Court of Appeal made clear that it must follow the California Supreme Court unless the United States Supreme Court has decided the same question differently. Viking then asked the California Supreme Court, please review our case. The California Supremes denied that request. Viking then petitioned the US Supreme Court to review the case, arguing that the Iskanian case was wrong. It directly conflicted with the US Supreme Court precedent, and that the FEA preempts any rule that would interfere with the enforcement of PAGA waivers. So that is how Viking got in front of the Supreme Court. The specific question before the Supreme Court: does the Federal Arbitration Act preclude an employee who has signed an arbitration agreement from bringing a representative PAGA action? Supreme Court has not, US Supreme Court has never addressed that. As Anthony mentioned, the California Supreme Court has, and so there is this divergence of views, and that is why this case is so important and has substantial potential to impact California employers throughout the state. So there's a lot of implications. Some of these we're predicting. We don't know the exact contours of what the ultimate decision by the US Supreme Court will be, but for sure we know that first and foremost, there will be a ruling to clarify on whether PAGA waivers in employment arbitration agreements signed in California will be enforced under the Federal Arbitration Act. If the Supreme Court rules in favor of the employer, I think no doubt the landscape of wage and hour litigation in California will be altered substantially. Employers, in that case, employers will be able to enforce arbitration agreements with PAGA waivers in the exact same way that they do now with class action waivers. And that would result in a substantial cost decrease to employers involved in these litigations. The arbitration proceeding of an individual claim is going to be much less, both in the settlement, the costs, and the attorney fees, than if it was an aggregated claim on behalf of the entire workforce filed in court. So what this, if there is a favorable ruling by the Supreme Court pro-employer, what will happen is defendants would then, who have a current case, would ask the court to dismiss the PAGA case, and to the extent that the plaintiff chooses to pursue any individual claim he or she may have, then they would be obligated, they would be compelled to litigate that in arbitration. So even a favorable ruling on behalf of employers is not going to mean the end of all PAGA litigation. One, a ruling in favor of the employee would likely not bar PAGA cases where the named plaintiff did not sign an arbitration agreement or where the LWDA is pursuing the claim. And two, even with a pro-employer decision by the Supreme Court, it's very possible that the California lawmakers would redraft PAGA to survive that pro-employer ruling. And one other thing I wanted to point out is that, we're talking about the California statute, the PAGA, and all these California cases, but however the U.S. Supreme Court decides whether it's pro-employee or pro-employer, it's probably going to have ramifications well beyond California, because currently there are other states that are considering enacting laws that are similar to California PAGAs.